Monday, February 4th, 2013. It is just past 7:30 p.m. We are in Riverside Township Hall, room 427 Riverside Road. Welcome to everybody who is with us today on one of our finally legitimate winter days. We actually have a little snow on the ground and some rather cold weather out there, so thank you for joining us today. Welcome. Residents and visitors are welcome to all meetings of the Village Board. Comments and suggestions on any topic are welcome at any regular meeting. Comments may be made during the time identified for public comment on the agenda, or if the comments pertain to an agenda item at the time that item comes up for discussion. Individuals who wish to comment must be recognized by the president and then speak at the podium, and should begin by identifying themselves by name and address so that the village clerk can add this information to the meeting minutes. Please note that while the village code requires 2 readings of an ordinance, it also provides that the board can waive the second reading and take final action on an ordinance at any time by the vote of a concurrence of a majority of all members then holding office. So with that, once again, welcome to those who are with us today, those who are watching at home, where it's a little, they didn't have to get out and brave the elements, on Channel 6, those who tune in to the DVD, which will be in the library later this week, or to those who pick up our meeting, which will be up on our village website shortly. So with that, I will ask our village clerk to please call the roll.
President Gorman.
Here.
Trustee Sussman.
Here.
Trustee Sells.
Here.
Trustee Reynolds.
Here.
Trustee Valerie.
Here.
Trustees Shevitz and Sachi are not present this evening. Village Manager Scalera.
Here.
Village Attorney Molina.
Here.
Village Attorney Mars.
Here.
And Village Clerk Kathy Haley also present.
Thank you. We have a quorum, so we shall proceed. With that, I would ask everyone to rise and join us in the pledge, and I will ask our village attorney, Michael Mars, to please lead us in the pledge.
I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
And we have no special presentations at this meeting. However, I will now open the meeting up for anybody who would like to address the board at this time. Seeing no one, we shall move on with the agenda. First up is the reports of the village officers. President's report during our last meeting was just short of 2 weeks ago. During the last 2 weeks, I've attended some meetings of West Central Municipal Conference, a quarterly meeting, a legislative committee meeting, and a economic forum held in conjunction with Elmhurst College. I also had the opportunity to attend the Vanguard Healthcare McNeil Memorial Legislative Breakfast and had an opportunity to hear Senate President John Cullerton talk about what is on all of our minds, and that's the state of Illinois finances. Also, last week, along with Trustee Sussman and Village Manager Scalera, we attended the Northern Illinois University Financial Forum held at the Northern's campus out in Naperville. Always good to hear this time maybe a little more optimistic things about the economy, so we shall see how that bears out. And that concludes my report, and with that I will turn it over to the Village Manager.
Do not have your report this evening.
Can I ask you a question? Sure. Given what happened at the Super Bowl last night, are you prepared if the power goes out here or anything tonight?
We should be okay.
All right, that's what we need to hear, so thank you. Village Attorney Lance Molina.
I have no report.
Thank you, Lance. We shall move on to the approval of the consent agenda. On tonight's consent agenda are the approval of the bills of February 4th, 2013, and approval of the Village Board of Trustees regular meeting minutes of January 22nd, 2013. Does any trustee require any item to be removed for discussion? If not, then I shall ask for a motion and a second to approve the consent agenda.
So moved.
Second.
So a motion by Trustee Reynolds, second by Trustee Sussman. And with that, would you please call the roll, Kathy?
Trustee Sussman.
Aye.
Trustee Sells.
Aye.
Trustee Reynolds.
Aye.
Trustee Valerie.
Aye.
And with that, the consent agenda is approved. Thank you. Moving, no, we have four. No,
No, we have 4.
no, we have four trustees here besides myself.
Everybody who's a trustee raised their hand.
We're okay.
Thank you for being attentive to the role. That is always important. Next, we shall move to reports of the board chairpersons, finance, personnel, and preservation. Trustee Sachi, who is not at tonight's meeting, I will ask the village manager to please handle those items.
Sure. The first item is a second reading of an ordinance amending the village code of the Village of Riverside, Illinois, relative to requisitions and purchases. Pursuant to Title I, Chapter 8 of the Village Code, Riverside Municipal Code provides that the village manager the authority to purchase supplies, equipment, and enter into contracts for work and public improvements not exceeding $10,000 without board authorization. The existing ordinance granting the village manager with spending authority up to $10,000 was last updated in 2004. Since the cost of material, supplies, equipment have increased over the years, many purchases not requiring board approval in the past now require board action, creating inefficiencies in service delivery. The suggested spending threshold is comparable to that of other communities as well as state statute, which was amended, raising the $10,000 threshold to $20,000.
And with that, thank you,
Yes.
Peter. And with that, I will ask for a motion and a second. This is a second reading of this ordinance. We discussed it at our last meeting. If I could have a motion and a second.
So moved.
Second.
So I have a motion by Trustee Reynolds. This time we'll go to the left, and I heard a second by Trustee Ballerine. Thank you, Joe. Is there any further discussion on this item? Hearing none, I will ask for the roll, please.
Trustee Sussman.
Aye.
Trustee South.
Aye.
Trustee Reynolds.
Aye.
Trustee Valerie.
Aye.
Thank you, and that ordinance is approved. Peter, you have another item?
Sure. The next item is also a second reading of an ordinance amending the village code of the Village of Riverside relative to the position of village clerk. Pursuant to Title I, Chapter 9 of the Village of Riverside Municipal Code, the village clerk is appointed by the village president with the advice and consent of the Board of Trustees. As a result of the retirement of village clerk Arlene Blaha in September of 2012, the village board, at their September meeting, appointed Kathy Haley as our village clerk. Prior to 2008, the village clerk was an elected position. However, a vote to change the office to an appointed position was successful, and appointment and removal authority for this position was given to the village manager. In an effort to streamline services, staff recommended and the village board approved as part of the fiscal year 2013 budget that the office of the village clerk be merged with the village manager's office. As a result of the September 17th meeting, the portions of the village code relative to the office of village clerk need to be amended to reflect the consolidation of the two offices.
Thank you, Peter. And again, this is a second reading of an ordinance that was discussed at our last meeting, and I would ask for a motion and a second to approve this ordinance.
So moved.
Second.
So I have a motion by Trustee Sussman and a second by Trustee Reynolds. Is there any discussion? Hearing none, Kathy, would you please call the roll?
Trustee Sussman.
Aye.
Trustee South.
Aye.
Trustee Reynolds.
Aye.
Trustee Valerie.
Aye.
Thank you, and that motion, ordinance is adopted. Peter, I will take the third one under Trustee Sachi's agenda here, since this deals with your employment contract.
Thank you.
On October, we have a second amendment to an employment agreement between the Village of Riverside and Peter Scalera. On October 1, 2009, the Village of Riverside Board of Trustees approved an employment agreement with Peter Scalera. For the terms of the agreement, an annual review and consideration of a compensation adjustment must be completed subsequent to the anniversary date of the contract. The Village Board, following discussion of Mr. Scalera's performance, agreed that he has performed his duties favorably and has agreed to an increase of his base salary of 3%. Attached to this second amendment is the second amendment between the Village of Riverside and Peter Scalera. So with that, I would ask for a motion and a second to approve this resolution for the second amendment to the employment agreement.
So moved. Second.
So we have a motion by Trustee Ballerine and a second by Trustee Reynolds. Is there discussion on this item? Hearing none, I will ask for the roll, please.
Trustee Sussman.
Aye.
Trustee South.
Aye.
Trustee Reynolds.
Aye.
Trustee Valerie.
Aye.
Thank you, and that second amendment to the employment agreement is approved. Thank you.
Thank you.
Congratulations.
Thank
Good job.
Mr. President? We have two individuals here, at least two, I think, who'd like to speak about the zoning
Yeah, we could,
variation,
sure.
if you don't,
That's-
with everybody's permission.
That's fine, we can move that up ahead of the next item. So we shall move to item F, which is building, planning, and zoning. Trustee Sussman.
Okay, thank you very much. This is the second reading of an ordinance approving variations for maximum lot coverage and rear yard setback to allow construction of a rear addition to the single-family residence at 52 North Delaplane, which is at the corner of North Delaplane and Herrick. The applicants submitted a request for two zoning variations, seeking relief from the rear yard setback and lot coverage requirements. Petitioners desire to construct a one-story addition at the rear of their existing one-story residence. They seek variations from Section 10.4.3, Table 3 of the Village of Riverside zoning ordinance, which requires that rear yard setbacks be 25% of the depth of the lot, and which also requires the maximum building coverage on corner lots in the R1A single-family residential zoning district, which is important, and I'll get to that, not exceed 30% of the lot. Petitioners are seeking a 10-foot variation to the required rear yard setback for a total setback of 28.33 feet. They also seek relief from the 30% lot coverage requirement. They would like the residence, in addition, to have a footprint not to exceed 35% lot coverage, and not to exceed, I believe the final design is not ready yet, and so it will be no more than 35%. The proposed addition will include a dining room, there is no dining room, and an additional bedroom and bath. There was a public hearing on November 27th. At the public hearing, the Zoning Board of Appeals voted favorably 6-1 in favor of recommending the approval of the setback variation, and 5-2 in favor of allowing the variation for lot coverage. Pursuant to the village's zoning ordinance, a variation may be approved, and we have a special sheet on that. If my fellow trustees could turn to the Riverside Zoning Code standard for variations. The Zoning Board of Appeals shall not recommend varying the provisions, and I'm not reading off of the agenda item, I'm reading off of the sheet from our zoning code. The Zoning Board of Appeals shall not recommend varying the provisions of this zoning ordinance as authorized in this section unless it has made the following findings based upon the evidence presented to it. A, that the owner of the property in question will suffer undue hardship, which is a legal definition, in the absence of such variation. B, that the plight of the owner is due to unique circumstances. C, that the variation, if granted, will not alter the essential character of the locality. What's important here is that a variation shall be recommended only if the evidence in the judgment of the Zoning Board of Appeals sustains all three of these conditions which I just mentioned. For the purpose of supplementing the above standards, the Zoning Board of Appeals may also take into consideration the following: that A, the particular physical surrounding, shape, or topographical conditions of the specific property involved will bring a particular zoning hardship upon the owners as distinguished from a mere inconvenience if the strict letter of the regulations were to be carried out. B, that the conditions upon which the petition for variation is based would not be applicable generally, that was the uniqueness, to other property. That the purpose of the variation is not based exclusively upon a desire to achieve a higher profit, that the alleged difficulty or hardship has not been created by any person presently having an interest in the party, and that the proposed variation will not impair an adequate supply of light and air to the adjacent property or substantially increase the danger of fire. Okay, so that is, as I read, the Zoning Board of Appeals, based on the three criteria, voted in favor of both the requests for variations. I talked about this at great length at the last meeting. I would like just to point out a couple of things in the findings of fact, which Mr. Mars put together. He's the legal representative at our Zoning Board of Appeals meeting. Under public hearing, the bottom of the first page, the middle of the paragraph, The sweeping curve of the dedicated Delaplane right-of-way as it turns into Herrick is unusual when compared to the conventional squared-off turn at the actual street intersection. This was brought up by the architect many times and is actually in the petition. Then at the top of the next page, petitioner's architect pointed out that the maximum lot coverage for corner lots in certain other residential zoning districts within the village is 35%. I wanted to clarify that. The R2 district, which is the zoning district of single-family homes, does not allow any home to exceed 30% of the lot coverage. This is true for corner lots, for middle-of-the-block lots, for lots across the street. In the case of the residential districts where there are multi-family units, then in fact, corner lots can go up to 35%. But several people have said something to me about this, and I want to be very clear that the zoning code for single-family homes, which this home falls within, does not exceed 30% for any property. Okay? And then the petitioners went on to explain why, I think everybody's read this, why it's a hardship not having a dining room, an additional bathroom, and bedroom. So unless there are any questions, I think I'd like to hear a motion.
So moved. Second.
Okay.
So we have a motion by trustee Sells and a second by trustee Bellarine to approve these two variances by way of this ordinance. This is a second reading. It was also discussed at our last meeting. So with that, is there any discussion?
I would like to start some discussion. I have some concerns about granting these variations, and I know that the homeowner and the architect are both here, so thank you, gentlemen, for both coming. I've just gone through the standards for variations, and each of those three standards must be met, not just one, not two, but all three. And I actually have concerns about two out of the three standards. I'd like to start by talking about uniqueness. And what that means is you can't point to other areas, other properties in the area, or in this case in an R2 district, that have those same conditions. And in fact, there were a couple of points raised by the petitioner. One was that it's a corner yard lot. Well, there are many corner lots in the R2 district. And these corner lots have not come forward and also said that they require 35%. But there are many corner lots, which in my opinion means that it's really not a unique situation. And in fact, the Plan Commission, in going through the zoning ordinance, did acknowledge there are corner lots and that should remain at 30% coverage. The second point that was raised that raises questions for me about uniqueness is the question about the right-of-way and the fact that in this case, there's a rounded corner, but that, in fact, the right-of-way is quite large. And in Riverside, we all, or most of us at least, have very large right-of-ways. So this, for me, again, is not a unique situation. The fact that I think the fact that there is land in front of the house, a part of the property that we're all required to mow and maintain, that is in the village right-of-way. And by the village right-of-way, that means that it's not, that it is subject to village regulations on zoning and on planting and all sorts of things. So for me, both of those conditions are not met with respect to uniqueness. The other concern I have has to do with the hardship. And hardship, well, there are a couple of things that I'm concerned about with this. One part of the hardship regulation or variance condition has to do with the circumstances behind the request. And the circumstances, even I think in court cases, and I'll look to our two lawyers, aren't so much about changing conditions of the petitioner, of the owner, as they are about the land itself. So the fact that I own a house and need to use it for other purposes, whether it be a business or additional family members, is not about the land, it's about my changing conditions, and that really is not a part of the definition of a hardship. But having said that, the most telling part from the handouts that I got from the architect was that the petitioner didn't seem to require the variations to achieve his or her, to achieve the family's objective. The petitioner, and we only heard from the architect in the presentation, wanted an additional bedroom, additional bath, and a dining room. All three of those, even if we could have the discussion about whether it's necessary to have those in a house, whether you could resell the house, that's another discussion because the house has been resold. So for me, that's really not an issue. But regardless, there are other ways that the petitioner could achieve those goals. The petitioner, for instance, and actually we asked the architect that, you could build up, you could build forward. You do not need variations to achieve the goals of having an additional bathroom, bath, and dining room. So again, regardless of whether we agree on whether or not these are hardships, not having those 3 rooms, the fact is that those rooms could be added without granting a variation. And variations are something that we're supposed to be very careful about. Really, they're the exception to the zoning rule. And so I would like my fellow trustees to consider my comments. Thank you very much.
Thank you, Trustee Sussman. Any other comments? We have,
If they would.
yes, what was my next point there? We do have the owner and the architect here. Would you like to hear from whom?
Yeah, whichever would like to address. But either of you like to address with Trustee Sussman, just.
I'm Ken Circo, Circo Architects, 404 Addison Road. Thank you for seeing us again tonight. I guess I initially want to start out by saying that we've gone through the Zoning Board of Appeals process, which, as you could tell by the lengthy package that we submitted, was very thoughtfully put together. And I guess just going into this initial round of discussion, I'm questioning what sort of merits the Zoning Board of Appeals has versus, the member of the trustees and members of this board in particular. That being said, we've presented this, and I think everyone is familiar with the project. I think each time we've presented this, sort of the criteria that we need to meet for the zoning variance seem to get watered down and beaten up over and over. So I'm curious to know what the procedure is for how we're approaching this. To address some of the other questions that we've talked about before, uniqueness. Trustee Sussman, yeah, there are many corner lots as you mentioned, in an R2 zoning district. This is actually in an R1A. And a lot of corner lots in this village are different. I'm personally working on another project that has the same ridiculous slice off the corner of the property where the conceived amount of land that these people have is really disproportionate to their actual holdings in what their property is. And that kind of ties into what the right-of-way issues are with this. You mentioned that many people in the village have large right-of-ways. I disagree with that as well, and I respectfully disagree. A lot of interior lots in the village, and we have especially long city blocks, the right-of-ways really are the area designated between the curb and within a few feet of the other side of the sidewalk. In some cases, there's an 8-foot parkway, some there's a 10, and a 5-foot sidewalk. So I really don't feel that that's an extreme large right-of-way that a lot of people are afforded. The land versus the changing conditions of the property and the house and all that, we can look at the land as an individual entity, but the fact of the matter is there's a single-family residence with residents living in the single-family residence on this property. So I think you have to kind of look at the lot and the house as one entity. And corner lots are goofy. They're always goofy. There's whole sections in the zoning ordinance, as Mr. Caraher could point out, of exceptions to the rule. The village of Riverside has a lot of exceptions to typical zoning rules because we have pie-shaped lots and oblique-shaped lots and these strange things. Just that, given those merits alone, that's a very difficult village to. This is a difficult village to build in and to calculate any type of considerations for. I just want to sort of re-emphasize sort of what the items that we're requesting. The uniqueness. I think it's a very unique lot, and the fact that the house is situated in a unique position on the lot makes it very difficult. The fact that the house is in a village where almost all the adjacent properties have afforded the same amenities that we're requesting: a dining room, additional bedroom, additional bathroom, additional living space. I don't think that's excessive to request. We've gone through the package, we've looked at everything, we've discussed some of the specific issues of this. I feel that the percentage of lots based on the goofiness of the lot and the shape of this lot kind of allow us for a little bit of leeway in terms of the variation request for the 35% buildable. Yeah, we could reconfigure the home in a different fashion, but that's not going to work. And I think that our notes from the last meeting even say that, we're trying to keep the house as far back away. We're trying to preserve green space. We're trying to match massing. We're trying to, make this a pleasant house, a pleasant addition to the village. The encroachment into the rear yard, even though technically, yes, we are encroaching in the rear yard, we are still at an average of about 44 feet away from the nearest adjacent neighbor to the side that we're encroaching on. Given that instance, there are some houses that are practically on top of each other, given the right-of-way standards and all that, setbacks and whatnot. We also have, and it was entered into the Zoning Board of Appeals documents, signed affidavits from the adjacent neighbors to both the west and the north, saying that they're fully aware of the project, fully aware of the design intent, and any grading and light and quality of air issues. They have no issues, and they signed off and respectfully agreed to the scheme of the plan that we're going through. So I think, given all those, I would just like to request that you consider this case and consider the plea for my client. I don't know, Doug, would you like to speak as well?
Wait.
Please.
Before you
I'm
step
sorry.
down, Mr. Sir, does anybody have?
Yes.
No, but
questions?
thank you, Mr. Sirko.
Thank you.
Okay, if you would please.
Doug Gibson, 52 North Delaplane. One thing that cannot be mentioned this time was that initially when we purchased the property, on the Riverside website was a document that stated corner lots are allowed 35%. So that was one of the things that we factored into the whole idea of buying this place with the intent of building on. I think you did go through the whole green space. If we follow the strict letter, not requesting any minimal variances, the addition would theoretically work, but it would encroach a lot more into the green space, and it would defeat, I think, the idea and the intent of the rules that are in place to allow for as much green space and parkway as possible. That's it.
Thank you.
And I think that's a very important fact. I mean, I'm sure that the architect can put an addition on his house, can either go up or go different or do whatever. But I think, in order to preserve the character of our village and, keep the integrity of our village, additions need to be done right. And I know that's aesthetics, but I think in this case, this addition is done right for this house. And, that is a large piece of right-of-way. I mean, if you look at my house, my house, if you say 14 feet by 75, I'm giving up, 1,050 square feet. I bet you he's giving up, I think they're like 9,500 is their taxable square feet. I bet you they're giving up 3 times that. So, 3,000 square feet. So he's giving up 1/3. So I would rather see an addition done right. And that's, I think, why we have the Zoning Board of Appeals. That's why we have the appeal process. If we didn't have an appeal process, if we didn't grant appeals and we didn't look at these things, then you know what? We don't need a zoning board of appeals.
Well, I agree, Joe, except the zoning board of appeals is not an architectural review committee.
I understand that. I didn't say they were, but I'm just saying, if we didn't have a process in which we can look at a project and say whether it's right or wrong for this village, then we shouldn't even have, we should just say this is our zoning, this is it, live by it, go. But we don't. We have an appeal process. And that gives us the opportunity to look at these things in depth and try to see irregularities. And we are a village of irregularities. And we are also a village of some horrible additions. I would like to minimize those as much as possible. And I think that this architect and this homeowner has done a very good job of doing that. And I think it's going to be a beautiful addition and a wonderful additive to that neighborhood, to those neighbors, and to their quality of life. So I have no problem. I know it doesn't meet all of the restrictions and all of the hardships, and you can go on and on, but that's why we have an appeals process, and I think you've done a good job.
Any further discussion? Jim?
Why do we bother writing these codes if we're not going to adhere to them, first of all? Secondarily, I don't feel it meets the hardship requirement. And thirdly, this board is not an arbiter of taste or architectural style. We simply have to take a look at the ordinances and decide whether or not this fits. Whether you like it or you don't like it, I think is irrelevant, actually.
I agree. I think that you can't say, Joe, well, maybe it's a hardship, maybe it's not, but I like it, therefore I'm going to vote for it. That's not what the law, it's a law.
And there's also a variance, and that's why we have a variance process.
But the variance process isn't because you can say I like it, so therefore I'm going to vote for it.
I like it, and therefore I'm going to vote for it.
Well, and I trust, and as we all know, and as Trustee Valerie knows, there's requirements to be considered where each to apply the facts and circumstances as each trustee sees fit under circumstances. So, Trustee Sells?
First, to address the uniqueness aspect, Trustee Valerie is correct about this, is that, a quarter of this property is eaten away by the right-of-way. And I think you'd be hard-pressed to find a lot of properties in this town where a quarter of their property has been lost to the right-of-way. So I have no problem with the uniqueness aspect. The most interesting part of this always has to do with the question of undue hardship. And I think they do meet the criteria for undue hardship. And one of the things that we have gone over and over again in the past is, are we going to follow kind of the traditional, what I would consider the more hardline view of what undue hardship means? Or are we going to adopt a more evolving kind of perspective on what undue hardship means, which is what our Zoning Board of Appeals has chosen to do. And I think it is relevant that by an overwhelming majority, our Zoning Board of Appeals has approved this process. So from my perspective, I think that as a Board of Trustees, we need a compelling reason to overturn the Zoning Board of Appeals. Now, prior to the meeting, I was speaking to our village attorney about this kind of evolving idea of what undue hardship means. Because Trustee Sussman seems to be suggesting that there's only one statutory meaning to undue hardship. And I don't really think that that's the case. And so if I could ask our village attorney to kind of, and to talk a little bit about the evolving nature of what undue hardship means in cases for variations.
Okay, I can do that. Let me do that by starting just by describing the original purpose of zoning laws and the way that compliance was to be encouraged. And a classic example is in some older municipalities, before there were setback requirements, people could build anywhere on the lot. And so in some older suburbs, you'll see houses with setbacks, and almost all of them are, within a few feet toward the front of the lot. And then all of a sudden, you'll see some real old-looking farmhouse-type building, and it sits way at the back. It's nowhere like any of the others. And the way traditional zoning was supposed to work is to encourage the tearing down of that house and the rebuilding of a new house in full compliance with the zoning laws. So you'd have uniformity and compliance with the zoning laws, and that was the purpose. And so the whole idea of legal non-conforming uses, whether you allow them at all or requiring them to be extinguished or whether you'd grant variations, traditionally things like trees and structures were not considered part of the lot the way a hill, the change in grade is, for example. They were considered expendable. So that if all you have to do is cut down a tree to meet a setback, well, we're not going to grant a variation from the setback requirements. You just cut down the tree. Or you're going to tear down this old house, put up a new one. I think the current thinking of many, many municipal elected bodies is different from that. And things like structures, maybe not so much detached garages, but sometimes even those, but the residential structures and trees, mature trees, particularly if they're of native, their value, are thought of differently in today's society. They are given value, and they're thought of as being, in many cases, part of the setup of the land. And one of the reasons is because you want to discourage cutting down mature trees. Another, as it relates to houses, is we no longer value compliance with zoning if it's going to require a tear down. As a matter of fact, many municipalities like to preserve the older style of house and would prefer a rehab or remodeling rather than a tear down. And if you're going to accept that as a model, in other words, you are going to value an older structure as something worth preserving as part of the land that you have, then I think that raises the addition issue, because many of the older structures are smaller and people want to do additions. And then the issue becomes is if you can do an addition, but you're going to wreck what you're trying to preserve, and this gets in a little bit into taste, but not so much what color it is, but more the basic, is it a ranch style and are we preserving that? Then I think you do find boards that are willing to look at, if we want to preserve the house, and that's a value as part of this land, here's where it sits now. Yeah, we could go up, but it wouldn't be a ranch anymore, and then I guess maybe we should tear it down. Or if we're going to go to the side, do we want to maintain some balance to that existing structure as it relates to the setback requirements or whatever? And so I think it's legally defensible. It's certainly not necessary. Communities are free to impose a more traditional view of hardship and uniqueness, but I think that it's within the discretion that you have to look at those things and to tie them always back to the uniqueness of the land. Things like that are only there because the individuals who happen to be there are using it for a specific purpose or have specific unique circumstances to their lives. Those should never be considered because they're not tied to the land. The people will go one day. But the fact of the matter is, you hope the quality houses, the high quality houses of historical significance and importance will be there and remain there. So that's a kind of long-winded explanation. Did I answer the question?
Yes. And it seems to me that really is the policy issue for us, is, are we going to adhere to, what this traditional view that the only thing that we take into account is the land itself? Or, as Mr. Sirko alluded to, are we going to talk about the land and the property and even the green aspects? You mentioned trees. I would consider green space to be a relevant part of that consideration as well. So if we're gonna take that more, what I would consider to be a more progressive view about looking at the situation in its entirety, it seems to me that this does satisfy the undue hardship. Because we have, first you've got the unusual right-of-way taking up at least a quarter of their property. I think it's unrealistic to tell someone who has a beautiful ranch-style home in our community to say, well, we want you to put a second story over there. Because now you've basically destroyed the integrity of the home. And I think that we want ranch-style homes in Riverside. With regard to the location of it, whether it's set back or set forward, it seems to me it's in our interest to preserve that green space close to the sidewalk and to the street. So all of those things to me militate in favor of agreeing with our zoning board of appeals, who had a lengthy discussion about this. And it was very interesting to me that if you read the transcript, that zoning board of appeals basically has opted to go for the more progressive view of the definition of undue hardship. So that really, it seems to me, is the question for us. You know, are we going to accept that more progressive view? Or are we going to adhere to what charitable or traditional view? And I would hope that we would take the former.
I have a question for you. Well, first of all, Trustee Sells, the use of progressive versus traditional is something that I would object to. I think just because somebody chooses, I choose to use the traditional definition, which is a part of our zoning code, doesn't mean, I think the implication that it's not progressive is something. But that's my question. That's my question for the attorney. There are communities that actually soften the definitions used, the criteria used. I think the question I have is that it is in our statute, this definition. And so is it, to Ben's point, is it actually a policy decision that we need to think about? Is this something that the Plan Commission, I mean, in other words, I guess my question is, my understanding is this is how it stands now in our statute.
Well, when you say statute, you mean ordinance?
In our ordinance, yeah. I mean, we can talk a lot about our, if we need to have a different ordinance, if we need to start articulating additional criteria that we should use in helping formulate policy decisions or zoning variance decisions. But in fact, we haven't had that discussion as a board, and we haven't charged the Plan Commission or the Zoning Board of Appeals with that discussion. And while I understand what Trustee Sells and Trustee Ballerine are talking about, it seems to me not appropriate right now to say, well, we are going to be changing the way we make decisions without a full discussion at the appropriate board level.
I guess I would have two things to say to that. One is, we haven't had a lot of variations, but this board hasn't really voted in, to my knowledge, in a completely strict manner. It's taken into account some other considerations before. And one of the things that the courts do when they look at an elected body and the way it makes its decisions is it accords that body deference in interpretive aspects of it. Undue hardship means, I mean, it's not a strict meaning. It never has been. It's varied even when it was viewed more strictly. And the courts have given that some leeway. What they look for, though, are obvious cases, at least in the court's view, where maybe a municipality has been interpreting it more flexibly and then interprets it strictly on this one particular property. They look for the pattern, and one of the things that litigants do when they look at land use regulations and ordinances is, what is the practice? What's been the history about variations and lots and so forth? And so what I always say is, you want the interpretation that you use to be consistent. But it can develop over time, much like the common law of the courts does. Interpretation of undue hardship is a general term legally.
But how is it put into our ordinance such that everybody involved in this decision-making knows that it is, that the criteria have changed since the last time this discussion occurred, which was in 2000, whenever the zoning ordinance was approved? I mean, how do you don't codify it, or you just start articulating that you're...
You can try to codify it, but the very idea of the fact that you have variations and that they're authorized by statute is a recognition by the law that you won't be able to define everything in a way that meets every case. And one of the reasons, and this is one other thing that I wanted to mention, Trustee Sussman, when you talked about unique, in my opinion, and I think in the land use opinions, unique doesn't mean in the sense that it's the only one in town. It's partly that it's unique, it's unusual, and also unique in the sense that it's connected with the land. Because remember, land is unique. Specific performance of contracts is allowed for land when it isn't in general for contracts, solely because the law in our legal system says that every piece of property is unique. That's why you don't have to settle for another one if you have a binding contract. Land is unique because it's land. And so the real question is whether you view houses as part of the land or completely expendable. Because I think to take the real traditional view extremely strictly, you need to come to the conclusion that the house is expendable. And if you don't, you really don't have that philosophy, at least not completely.
I guess I meant uniqueness in the sense that if there are many corner lots with those characteristics, then we should change the zoning code.
Well, and that's another thing.
That's why I meant that it was not unique.
Many times, that's exactly how text amendments
Right, I
come to be. It's through a pattern of variations, but you don't realize there's a pattern until you get enough variation requests.
that.
And then you know what? Then it wasn't unique. But
Right.
yet you only realize that because you granted the others. You know what I mean? I think it's unique more in the sense of unusual or different from the standard. And here the situation would be is this. Here the unusualness could come about because of the corner lot. And some municipalities treat corner lots as unusual, per se. And that's a pretty open view because corner lots, we didn't expect there to be corner lots. Here it's a corner lot plus the sweep of the right-of-way, I guess, combined, and how unique it needs to be unique. Again, is somewhat of a policy decision, but I think that from a legal perspective, because it's tied to the land, it is somewhat unique already.
Okay, thanks. Thank you, gentlemen, for starting this discussion for us.
Well, and I think that's something that Lance said in passing is relevant too, because we have had this conversation before.
Yes.
And we have specifically addressed this question of whether or not we were going to include things like the structure and the trees as part of the overall parcel, or whether we were only going to look at the
But we
land.
hadn't decided.
And, well, we have decided, because we've granted variations based on taking those things into account. So it seems to me that this is something, this is not the first time this issue has been raised. Now, it may be that what we need to do, separate from this instance, is have a specific conversation about that. But even in that instance, since it's an evolving standard, it's more progressive.
Excuse me while I kick him in public.
That's going to change with the makeup of a board.
Yeah.
But I also would just like to go back to something that Mr. Serco said, and I would apply this not only to the zoning board. We have a commission structure for a purpose. And it seems to me when we get an overwhelming mandate like this from a commission, for us just to overturn it out of hand, we need to have a very compelling reason to do so. And I haven't heard that compelling reason, especially given the description of the flux state of the law that Lance has given us.
Trustee Reynolds?
Yeah, I think you can say in Riverside that a lot of our lots are unusual or unique or whatever the term is that you want to use legally. And I think that's one of the reasons we look at them on an individual basis. However, I don't think, I agree completely with Trustee Sussman in her opening statement that it doesn't meet two of the criteria. Certainly, the owners knew what the lot size was when they purchased the lot. They knew, what the circumstances were with the corner being in position there, and probably the right-of-way as well. I don't see a reason for us to, in your words, Ben, make a progressive choice here, since we have not had this discussion that Trustee Sussman has indicated. I don't see any reason for it. And Lance, I might ask you too, does that not set a precedent then if we have a string of those going forward? It seems to me that your advice was that that's what it leads to.
What? I'm sorry.
If we make a more progressive choice in a particular number of instances going forward, does that not then change the definition of, or change the precedent of what we've done in the past?
Well, but one would hope that you would, if you want to do it in a situation like this, you would want to do it again, because otherwise you'd be doing it for the wrong reasons. You know what I'm saying?
I agree.
Which would be because of someone, personal connection. But if it's a good idea, if the circumstances are present again that are the same, you should be prepared to go that way again or distinguish it. But that's true in general of everything that you do as an elected official. You want to, treat people consistently or treat requests consistently. So yeah, I don't think you want to use houses are not part of the land in one decision and then the next time say, oh, this one they're not. You wouldn't do that anyway. It's really more of a debate about how is this supposed to work? What are we supposed to do? And I guess the one thing I would say is, in my opinion, you are not hamstrung by the definition. You have the freedom to say, I think this should be the rule, or that more things, we want to take more into account than just, whether there's a topographical condition that makes the setbacks impossible and someone would be living in a refrigerator box in order to live on the land, something like that, that if you are, that you can take more into account than just the lay of the land or the shape of the lot. But even shapes of lots, if you bought it with that shape, you knew about it, but a court isn't going to let, if you end up not being able to build on it, that's not going to work either. At some point you're going to be forced to, if someone calls your bluff, to make some flexibility where you cannot get anywhere near the highest and best use for a lot that you zoned a particular way. So there are constrictions at both ends, but I would say this case is in the area where you have the freedom to do what you want, in my opinion.
Well, I think it's not just in this case. In all zoning cases that come before us, you are bound by the ordinance, but that ordinance inherently gives you the freedom to make a determination as to what factors determine unique. The factors that determine unique for one voting member won't be the same as the other voting member. The process for the Zoning Board of Appeals, as Trustee Sells has said, is they are the court of first resort. They hold the public hearing, they create the record, they provide an advisory opinion to this board. It is really up to each trustee to determine the weight to assign to that. I happen to believe that it should be given deference unless I strongly feel for reasons that you shouldn't abide by it. But an ordinance has to be amended by the village board. That's why it's before us. We look at the record, we hear you, we each have our own considerations, whether it's strict or liberal or whatever those monikers are. The ordinance allows each voting member to factor that into his decision. So we have had two discussions on this. We have a motion and a second on the floor. Given that we are a short board, what's the vote that's required for this ordinance?
It's an ordinance, so it requires 4 affirmative votes in order to pass.
Thank you. So with that,
Mr. President?
yes.
May I ask the architect a question?
Sure.
Given what we just heard about the nature of the vote.
Yeah, I did have a question.
When are you actually going to need to start working on this project? Not till spring, I assume.
We'd like to start construction in the spring, and obviously we're at schematic designs now, just to, we don't want to spin our wheels only to find out we can't do it. We would ideally like to have approval with this. We've been at this since October, maybe before October, getting all the zoning documents and the time period and all that, and the zoning board and the holidays and the first read and the second. Yes, I mean, we're really
I just wonder, though,
dragging
given the necessity for the 4 votes and that we're absent 2 trustees, if it wouldn't be worth tabling this until we have people back.
I don't agree with that. There's 5 of us that made an effort to be here. There are 2 members who aren't here for whatever reason. I mean, we conduct village business when it comes before us. I hear what you're saying, but we don't have a general rule that we need 7 members present in order to.
No, but we've made exceptions for votes sometimes.
I don't agree that we should table this.
If
you'd like to,
I move the table.
That's quite fine. So we have a motion to table this matter. Do we have a second?
Second.
So we have a motion and a second.
So that would put it up for the next meeting, correct?
Well, that's up
Well,
to you.
you can table it to the
specify,
next meeting.
yes,
Yeah,
I
you specify. And actually, you should specify.
I would say
because
table
it's a
until
published matter. so
Table
it
until the
should-
next regular scheduled board meeting.
Could you explain why you're proposing this?
Because I think it's an important enough policy decision to have the other 2 trustees present.
So if one of the 5 of us are missing at the next meeting and the other 2 trustees are here, what do we do? And what if there's not 7 at the next meeting? Just trying to beg the question here, because these gentlemen do want to have a decision.
I understand that, but I think we should table it.
But this is not a policy discussion, is it?
I think it is.
I don't think it
What does
is. I
undue
think it's an
hardship mean?
individual.
What does undue hardship?
I don't think we've had that
Well,
discussion.
we've been through that. It's each of us have heard each other talk. We've read the record. We've had 2 meetings on this. It's for each of us to make that decision.
Lance, what
So-
is the president's role in voting when there are 4 board members here?
He would vote if his vote was required. So if it were, for example, 3-1, there would be no point in the president voting because it couldn't change the outcome. It couldn't get it was against, 3-1. If it were 2-2, there would also be no real point in the president voting because although it would get a majority of this quorum here, it would not achieve the statutory required 4 votes to enact an ordinance. So, and on the other hand, if it were 3-1 in favor, then the president would be required to vote in order to see if it would pass, because if the president voted aye, it would get 4 affirmative votes and it would be enacted. If the president voted nay, then it would fail.
So we have a motion on the table to table this ordinance until the next meeting. Would you please call the roll?
Trustee Sussman.
Aye.
Trustee Sal.
Aye.
Trustee Reynolds.
No.
Trustee Valerie.
No.
It's a tie vote.
President Gorman.
Did you cover this in all those little explanations?
I didn't cover this one, but you can vote and should vote if there's a tie.
I'll vote to table this also. So this ordinance will be on our agenda of our next meeting, which is February 20th.
No, 17 or 18.
Okay? Thank you.
Okay, I'm going to just say for the public, just so there's no confusion, because this was merely procedural, even though this motion did not get 4 votes, it passed by a majority 3-2. So.
The motion to table passed.
Yes, motion. I just wanted to distinguish it in case people were confused, like I thought it.
Trustee Sussman, do you have anything further under your
No, I don't.
item? All right, we shall move back to the agenda. Public Works, Transportation, and Utilities. Trustee Sells. Ben, just 1 second. Go ahead. Yeah, go ahead.
I go back long enough in this village, so I remember a time when there was no variation in the zoning ordinance. And so does Gene Sussman, who
I do.
served on that commission at that time that I was chair of. And what concerns me is I heard a couple of times that people are, quote, giving up their land to the right-of-way. Well, that's not what they're doing at all. You own the property in back of the right-of-way, okay? That's what you pay taxes on. That's what you own. You get the benefit of that big sweep of land, you know? From the village, the taxpayers are paying for that, albeit that it's common practice to ask the homeowners to maintain that, sort of like up to the sidewalk and beyond. And that's a unique thing for Riverside.
And I agree with what you're saying, but according to his tax bill, he is taxed on 9,499 square feet. And in this particular instance, he's only given credit for 7,536 or something square feet.
You're trying to tell me we pay for the village right-of-way?
I'm telling you, when I looked up his tax bill online to see what the square footage of his taxable lot is, was 9,499.
Well, something's wrong. You're taxed on the property you own,
Okay,
not the village right-of-way.
Do we know the answer to that? What are we taxed on? We should all know what we're taxed on. Sorry.
You're not taxed on it.
Right, you're not
We're not
taxed on the
taxed on the
right-of-way.
right-of-way.
Yeah, you shouldn't be.
So you're not giving up, you're getting the advantage of all of that property. And in fact, we have very strict regulations with regard to what you can do on those on that public right-of-way. What the sidewalk can be and not be, what kind of trees you can plant and not plant. What you can't do is very strict. We don't enforce it, but it's there. It's there. and we should enforce it, which is why, if you go back 30 years, we didn't have a variation in those, in our zoning ordinance. And I only remember a very small handful of variations from the time that the process was adopted. And to be honest with you, the last one I remember was subdividing a lot that couldn't be subdivided because it was a foot short of the 100-foot frontage on Lionel Road. You know, that shouldn't have happened and didn't happen when the Plan Commission was in charge of subdivision plats. We didn't allow that subdivision. And it only occurred many years later under the variation ordinance, under the variation procedure in a zoning ordinance, okay? And when you begin to nibble away, yeah, so it's a foot, big deal, you know? It's like a foot and 40 square feet short of a legal lot, okay? But, yeah, it's close enough, you know, that sort of thing. When that creeps in, it begins to become a problem. And you have to remember, that's our inheritance of this wonderful thing called the Olmsted Plan that we love so much, right? This sweeping streets, you know, they're not perpendicular intersections, the thing we love about Riverside so much and has made us famous, basically. That's all I want to say.
Thank you, Richard. Going back, Trustee Sells.
I have a resolution authorizing the village manager to execute an agreement with the Cook County Assessor's Office for the purpose of acquiring geographic information system data. Each year, the County of Cook supplies the village of Riverside with a large amount of geographic information, GIS, data that keeps the village's data current and supports the village's process of viewing and creating maps. In prior years, municipal GPS partners filed the request for the data with the county on behalf of GIS consortium members. However, beginning with the 2010 data request, the county requires that individual consortium municipal members submit their own request and enter into a formal agreement with the county. So in order to obtain the GIS data, the village of Riverside must enter into an agreement with the County of Cook Assessor's Office. There is no cost to the village associated with the proposed agreement for data acquisition. So I move to approve the resolution authorizing the village manager to execute an agreement with the County of Cook's Assessor's Office for the acquisition of GIS data.
Second.
So motion by Trustee Sells, second by Trustee Ballerina. Is there any discussion? If I have a question, this is a repeat item. We have done this
Annually, yes.
just as a question of procedure. This agreement provides that it automatically renews each year for one-year term unless terminated 30 days prior to the expiration. So if that's the case, why is it before us now? Why has it been before us in the past? I mean,
Yeah.
it shouldn't be before us. We shouldn't be taking this action. You understand the point?
Yeah. If it's automatically renewable, it wouldn't have to come before you.
So should we be taking this action?
Well, I would say there's no harm in it in the sense that Peter may have wanted you to be aware of it. And there's nothing wrong with approving it, even though it's automatically renewable.
And didn't we get, were some of the terms slightly different in this one than the last one?
Yes.
Well, that's a reason they have it before us, but that isn't the way this should work. So I agree with you. Bringing us back into awareness on an annual basis has some value, but the way it should be brought before us should be not to approve a new agreement, but to...
In time enough to
This should come to us in November.
Right,
November or late October prior to its expiration. So this should come back before the board in the second meeting in October or first meeting in November this coming year.
So that if board members had problems
Or if you want to change.
Renegotiate, yeah, or make a change.
So we have a motion and a second, and if you would please call the roll.
Trustee Sussman.
Aye.
Trustee Sells.
Aye.
Trustee Reynolds.
Aye.
Trustee Ballerina.
Aye.
And that is approved. Thank you. Trustee Sells, anything further?
That's all, Mr. President.
Public Safety, Health, and Landscape, Trustee Reynolds.
I have no report this evening.
River Parks and Recreation, Trustee Ballerine.
I have no report, Mr. President.
And Public Relations, Economic Development, Open Government. Was there anything in that for Trustee Shevitz?
No.
Okay, with that, that concludes the business section of our meeting. We will hold an executive session to discuss collective negotiation matters. We will not reconvene in open session. We will not take any final action during our executive session. So with that, I would ask for a motion and a second to adjourn to executive session.
So moved.
Second.
So we have a motion by Trustee Reynolds, second by Trustee Sells. Could you please call the roll?
Trustee Sussman. Aye. Trustee Sells.
Aye.
Trustee Reynolds.
Aye.
Trustee Valerie.
Thank you, and the meeting is adjourned to executive session.